Hi guys, welcome back to my channel. So today in this video I would like to continue a previous video entitled Hong Kong Maritime Law and Insolvency. In most littoral countries, legislation has been enacted to bring into force the provisions of the 1952 Conventions on the Arrest of Seagoing Ships, which attempts to harmonize the causes of actions leading to an arrest. However, jurisprudence and traditional in different countries has led to different treatment of in-rem claims. For instance, claims for insurance premiums can lead to arrest in Estonia but not England. Upon arrest and sale of a vessel, the proceeds or sale are prima facie at the discretion of the court distributed as follows. The admiralty shall costs and expenses connected with the arrest of the vessel and its appraisement and sale, the cost of the arresting party, and the cost of the party who obtained the order for the appraisement and sale of the vessel for the period up to and including the order itself. Maritime liens, possessory liens, mortgages, and other statutory actions in personal claims. It can normally be secured, such as maritime liens and possessory liens are leapfrog ahead of secure claims. Furthermore, statutory in-rem claims enjoy priority over ordinary unsecured claim. The essential difference between statutory in-rem claims and maritime liens is that statutory in-rem claims only crystallizes upon the issue of proceedings. A maritime lien arises at the time of the underlying cause of action. Therefore, if the ownership or control of the ship changes between the time when the cause of actions arises and the issuing of proceeding, a statutory in-rem claim would be defeated, and the vessel could not be arrested. But the holder of a maritime lien can still arrest the vessel even if the vessel has been sold. The OWB collapse has thrown into sharp relief some of the issues that arise with insolvency and in-rem claims. In early 2014, OWB listed on the Danish Bourse, raising nearly $1 billion. OWB supplied some 7% of the world fleet with marine fuel bunkers. OWB was, however, only a trader. It did not physically place bunker on only a trade. It is not physically place bunkers on board ship. Within 6 months, OWB filed for insolvency. In general terms, OWB's business model was as follows. A ship owner would place an order for bunkers with OWB, who would then order them from a physical supplier who would place the bunker on board the ship. Usually, the contractual chains would be far longer and more complex than this. The supply of bunkers was usually on credit terms, and usually the contract would contain retentions of title clauses. When OWB filed for insolvency in November 2014, many ship owners had received bunkers on board but had not yet paid for them. Ordinarily, there would be no difficulty. the liquidator, or in this context the receiver appointed by the bank under a security instrument, would gather in the debt owed to OWB. However, the supply of bunkers to a ship is in fact an in-rem claim. It is an in-rem claim held by anyone in the supply chain. Ship owners were therefore presented with the proverbial hoops, son's choice: pay the receiver, liquidator, and face a potential arrest and claim against the ship, or pay the physical supplier and face a claim in contract from the receiver or liquidator. Furthermore, different jurisdictions around the world treat the supply of bunkers differently. In most common law jurisdictions, the supply of bunkers is a statutory in-rem claim, whereas in the USA and Panama, the supply of bunkers is a maritime lien. In most common law countries, the law applying to the classifications of a claim as a statutory in-rem claim or a maritime lien is local law. However, in recent Australian case, the court held that the supply of bunkers was a maritime lien because the supply was made in Panama. Even though under Australian law the supply of bunkers was only a statutory claim. Several legal challenges have been mounted around the world to try to resolve the impasse. In England, the matter has now been considered by the Supreme Court. The shipowner contended that he should not pay OWB, as OWB had never in fact sold the bunkers to him. Due to the credit terms and the retentions of title clause, OWB had failed to pass title in the bunkers to the shipowner. In a radical change to the law of the Supreme Court held that the sale of bunkers was not in fact a sale contract where the OWB had promised to transfer the title. It held that the shipowner was obliged to pay OWB. However, it did not resolve the issue with the physical supplier, who arguably still has an in-rem claim against the shipowner in respect of the bunkers. In Canada, the shipowner paid the bunker price into a trust account and asked the court to decide who should be paid. The court decided that OWB was entitled to its margin and the principal sum should be paid to the physical supplier. The decision has been appealed and has been heard by the appeal court. A decision is awaited in New York. There are after 20 pending cases similar in the Canadian case, all which are awaited eagerly by shipowner and the receiver of OWB alike. This state of uncertainty globally as to how claims should be treated and the ensuing priority serves to underline the fact that the maritime insolvency hold many pitfalls for the unwary. So this is the end of the article. Don't forget to watch my previous video and also don't forget to like, comment and subscribe. Bye.